Hindu Minority and Guardianship Act 1956 under Section 4 defined about the minors, and as per the provisions of Section 4, minor here defined as the very person not completed the age of 18 years, and so guardian is also defined under this section, and here it is defined guardian as natural guardian, guardian appointed by the will of the minor's father or mother, or guardian appointed or declared by a court of law, and a person empowered to act as such by or under any enactment, and section 6 which deals with natural guardian. So the very person or of an unmarried girl in connection to guardian, the father, and after him the mother, and that minor must below 5 years of age, and in case of below 5 years of age, the mother is the guardian of such minor, boy or girl, and the second one, illegitimate boy or an illegitimate unmarried girl. In that case, the mother, after her father, is considered as natural guardian, and so in case of a married girl, the husband is considered as natural guardian, and by ceasing to be a Hindu or by becoming a Banapastra or a sannyasa, and in case of a stepfather or stepmother, they can't be natural guardian. So now we'll go to section 7 which deals regarding adoption. So natural guardianship of an adopted son who is a minor passes on adoption to the adoptive father, and after him to the adoptive mother, and section 8 deals with the powers of natural guardians. So reading that the natural guardians have the power to do all acts necessary and reasonable, proper, and for the protection and benefit of the minor. Also, without previous permission of the court, cannot mortgage or transfer by sale, gift, exchange, or otherwise any part of the immovable property of the minor. Also, they cannot lease such property for more than a term exceeding 5 years, or for 1 year beyond the date on which the minor will attain majority. Also, any disposal in contravention of subsection 1 and subsection 2 of section 8 is voidable. Also, the court shall grant permission only in cases of necessity or for an advantage to the minor, in cases of disposal of minor's property, and all application for such permission can be obtained under section 29 of the Guardians and Wards Act 1890. Before giving any such permission, the court shall follow the procedure and power specified under Section 31 of the Act of 1890. So the natural guardian has the power to appeal. The court here means the city civil court or a district court or a court under Section 4A of the Act of 1890, that is the Guardian and Wards Act. So, in that connection, we will discuss certain leading cases. And one is E.M.N. Nadar versus Sridharan in 1992. The Kerala High Court expressed that the powers of the father to act as natural guardian do not come to an end simply because the child is being looked after by his aunt and is living with her. And the second important leading case, Srimati Manju Tiwari versus Dr. Rajendra Tiwari in 1990, Supreme Court held that minor would be in custody of mother only unless it would be detrimental to his or interest. So, the welfare of the minor is the paramount consideration. And in the leading case Mohan versus Sandhya Mohan in 1993, the Madras High Court held that custody of 5 years old child should normally be given to the mother. However, in exceptional circumstances, the father of the child can also claim the custody. And the next important leading case is Vijay Lakshmi versus the Inspector of Police Station, Karur in 1990. The Madras High Court expressed that father of the minor marrying a Muslim girl after conversion to Islam cannot claim natural guardianship of the minor. And in the next leading case, Panilal versus Rajendra Singh in 1993, Supreme Court held that alienation of immovable property of the minor without any legal necessity or benefit to the estate and the court's permission also has not been obtained to this effect of the registration of sale deed would be void, not voidable within the meaning of Section 8 of the Act. And the next leading case, Ishok Khayal Nair versus Sridharan in 1992, the Kerala High Court held that on conversion, the father, the mother, or husband of the minor wife becomes disqualified to act as natural guardian. Similarly, when the guardian renounces the world, he becomes incompetent to exercise the power of guardian. And now we'll go to Section 9, which deals with Testamentary Guardian. So, also regarding appointment of Testamentary Guardians. So, Testamentary Guardian is a guardian appointed by a will of the natural guardian of the minor, as a will comes into effect only on the death of its executor. So, the testamentary guardian becomes functional only after the death of the natural guardian. So, following persons can be appointed testamentary guardian, and they are the natural father or adoptive father, the natural mother or adoptive mother, the widowed natural mother or widowed adoptive mother. So a Hindu father cannot appoint a testamentary guardian on the undivided interest of the minor in the joint family property as it remains in the hands of the Karta. So also a Hindu father appoints a testamentary guardian and dies, then his mother of the minor shall be the guardian only if she dies without appointing a guardian. Then the will of the father shall become effective, and in case the widowed mother appointed a guardian, then that will come into effect. And where the child is illegitimate, then the mother is entitled to appoint a guardian, and the father has no right to appoint any person as guardian. Also, a Hindu mother has absolute right to appoint a guardian when the father ceases to be a Hindu or becomes a sannyasi by renouncing the world. And lastly, testamentary guardian can exercise all the rights and powers of a natural guardian to such extent and subject to such restriction as are specified in the act or in the will as per the provisions of Section 9 regarding Testamentary Guardian under the Minority and Guardianship Act 1956 regarding the Hindus.